Hello, everyone. Welcome to the next installment of our clown parade that we call a broadcast. Welcome to another episode of the Justice Revolution. I'm your host, James the Patriot. I have with me my partners in crime. There's no pun intended with that one. Erica from the beautiful state of Indiana, and my producer and co-host, Justice, just to the north of me in about 15 feet of snow.
Yeah.
Did you unbury yourself?
Yes. Yeah.
That's insane.
We have all the equipment, so yeah.
So you have like a massive front end loader tractor to dig yourself out of that?
No, we do. We have a 1967 CJ Jeep named the General.
Oh, there you go.
Painted army green with a big star on the front, and can push snow straight up a tree. Amazing.
I like that.
Yep. And we have a snow blower with tracks on it. So
nice.
Yeah.
How about you, Erica? How's life in your neck of the woods?
It's interesting. My youngest son and I, we were just studying today about weather modification.
Oh, you got to be kidding me. That's hilarious.
Yeah, HARP and DARPA, they've been pretty busy. They're working on some projects. I don't know if what we're seeing is part of that.
Wow.
I saw them cutting down the HARP field in Brazil, the HARP plant, whatever you want to call it. I'm going to switch cameras here. I'll be right back.
No, you're good. You're good. Well, is it that one? That was weird.
Maybe.
There we go. Nope. Now you're muted. Oh, this is weird.
You muted again.
Yeah. This is very weird. Sorry, folks, are having some technical difficulties.
Still echoing.
Yeah, you're echoing.
Because you've got both of your mics are on. I think you need to mute one of them.
Yeah.
And, that's weird. Very weird. Anyway, while Justice is trying to figure out those issues there, it looks like it's coming through your. Yeah, it's that one. That's odd. I've never seen that before. But while she's working through that, let's go ahead and move into the meat of the show today. So I wanted to do a follow-up, so to speak, over the last two episodes we did the last couple of weeks, where we were talking about jurisdiction, how the court gets jurisdiction, the different types of jurisdiction, what they are, so on and so forth. We talked a lot about that. Don't think we need to go into too much more detail there unless we need a quick refresher. I'll leave that to you, Erica, if you want. We can do a quick refresher, or you think we're good? We can move on to the next subject at hand.
Go ahead, move on. Okay,
cool. By the way, Ian, thanks for being here from up north in Canada. I'm glad to see you're here. Etane and C to AZ. I'm assuming that's C to Arizona, but I don't know. Maybe it's just C to AZ. Thanks for being here, you guys. We really appreciate you guys showing up for our live streams. But for those of you who might be catching this broadcast not through a viewing, I will do my best. I'll do a better job of reading what I'm doing. So those of you who might be listening on a podcast or Spotify or Stitcher or something like that, it's sometimes I make the false presumption that you guys can see what I'm doing on my screen. So I want to make sure that we're all in line there. But let's get to our topic today. So we're going to talk about what happens if you get railroaded in one of these administrative courts, and you've been railroaded. You've done everything you're supposed to do, and we can talk about this down the road, but you filed motions to dismiss. You filed motions to dismiss because they don't have jurisdiction. They don't have subject matter jurisdiction. You've put all of that on the record. So what do you do now when the judge just says, I've got jurisdiction, and he or she issues a judgment against you? Now, if it's one that involves jail time, obviously that's a serious issue. If it's one of the more minor situations, like a traffic ticket or a minor misdemeanor that carries some type of a fine with it, this is going to become in real handy. And then on the flip side of it too, this also works in civil cases, civil matters that maybe you were sued civilly and a judgment was issued against you that you didn't know about, or maybe you did know about it and you tried to fight it, but they still issued it against you. But when you look into the record, you find out, whoa, wait a minute. The moving party never verified any of their claims. There's nobody verifying what their damages were. Nobody had standing to bring this. So the court didn't have jurisdiction. So we're going to talk about what to do there. So there's two different ways you can attack these types of judgments. You can attack them directly, or you can attack them collaterally, meaning you attack them in a different court. So let me pull up my screen. Let me get to where I'm going to go, and I'll show you where it is in law that allows you to attack this directly. And I'll give you my 2 cents on that as to why I'm not a real big fan of that. But let's get on down to where I'm at. Okay. All right, let me share my screen. And we will get moving into the good stuff. Share screen. Right here. Okay. All right. So back to my trusty Cornell Law. Love this website. They've got a great stuff. They got a lot of good stuff here. They can find everything you need. So I have on my screen right now, I have the rules of civil procedure, the federal rules of civil procedure. The majority of the actions that I'm litigating are in federal court, so that's where these rules apply. Now, you'll notice down here, Rule 60 talks about relief from a judgment or order. All right, so under this rule, it states that there's a number of things that you can seek relief from a judgment or order. So the first one is corrections on clerical mistakes, oversights, and omissions. That's just kind of a, that's a really small thing. But the second one talks about grounds for relief from a final judgment, order, or proceeding. And this is what the rule says. On motion and just terms, the court may relieve a party or its legal representative from a final judgment, order, or proceeding for the following reasons. Number 1, mistake, inadvertence, surprise, or excusable neglect. Number 2, newly discovered evidence that with reasonable diligence could not have been discovered in time to move for a new trial. Number 3, fraud. That's a big one. Misrepresentation or misconduct by an opposing party. Number 4, the judgment is void. Number 5, the judgment has been satisfied, released, or discharged. It is based on an earlier judgment that has been reversed or vacated, or applying it prospectively is no longer equitable. Or 6, any other reason that justifies relief. I mean, that basically just leaves the door wide open. So this rule governs the process if you're going to attack that judgment directly. So before I get into what that means, I want to open this up to you guys. What do you guys think that means when you're saying attacking the judgment directly?
I was going to ask you, what does that mean? What example is that?
Okay, good. That's a great question. Let me see. Erica, do you know what this means?
I am just very interested in this because I have a friend who is going through a foreclosure case, and this is applying, I believe, for her situation based on fraud. They didn't even give her a chance to, like, in the due process of things.
Yeah.
So
So there's, I mean, and Justice knows we're dealing with this very same issue with her. Fraud, right? So you have the party that's moving against you has failed to prove that they have standing to foreclose.
Right.
Well, they didn't. We started asking them for documents that proved they had ownership because my mortgage keeps changing hands. So I went out and reached out and I said, can you guys show me validation of my original documents? Who owns the note here? And nobody would. So for over a year, we asked repetitively through. So then we decided to sue them because they turned around and said, well, we're going to foreclose on you. And we're like, on what grounds?
Well, and here's the problem, right? So Justice brings up a great point because in her situation, she has been exercising administrative procedures, sending letter after letter saying, show me the validation that I'm looking for. I need to know that somebody will sign a document under the penalty of perjury that A, they have the original promissory note, and B, they have the mortgage deed. Those two documents are required for anyone to have standing to foreclose
or to collect money.
And to collect money.
I'm just saying, right? Show me that you have the right to collect money from me.
Exactly. Well, so here's what happens, right? These big bad companies, they're just like, well, the problem we have in this state here in Utah has a non-judicial foreclosure process. And all that is it means that the party that wants to foreclose, they can simply file a notice with the county recorder that, hey, we intend to foreclose on this property. Now, generally speaking, that's not a big deal. However, if they have failed, or either not failed or unwilling to prove that they have standing to foreclose, then how are you to put a stop to that? Because this is all administrative.
Mm-hmm. Right.
Everything we're talking about there is administrative. So how do you defend yourself? Well, you have no choice, but you have to sue.
Right.
And see, this is the problem that I have with non-judicial foreclosures, is it doesn't grant us the right to discovery. If you get to discovery, right, like you do in a lawsuit, it's simple. Hey, go ahead and provide a verified copy, one that we can inspect, one that the judge can inspect. And if you do indeed have verified copy and you are the owner of that, then hey, you have every right to foreclose.
Yeah, none of that happened in my friend's case, and the judge ruled to move the foreclosure, and there's a sheriff's sale scheduled and everything. So,
okay, so here's what your friend's going to want to do. So there's two ways, right? So the initial question was, when you're attacking it directly, what does that mean? Well, this rule states that you can file a motion to have the judgment vacated. It's called motion to vacate a void judgment, because right here it says the judgment is void, right? You guys remember what we talk about? What is required for the court to have before they can issue any binding judgment?
Jurisdiction?
Jurisdiction. Which type?
Subject matter.
Okay.
In personam.
And in personam. Correct.
In personam.
Yeah. Now, in property cases, in foreclosure cases, they also have to satisfy a third prong we didn't talk about, and that's called in rem jurisdiction, which means they have to prove they have an interest in that property. Okay. So in your friend's case, the company that was trying to foreclose, they must prove that they have clearly established the court has subject matter jurisdiction, meaning they're moving under a law or a common law or a statute that grants them that process, in addition to someone with firsthand knowledge and who has standing to foreclose has verified that claim with either an affidavit or a deposition, or they have taken some type of testimony under oath. That's required, number one. Number two, they must have properly served the other party. And number three, they must prove that they have an interest in the property, meaning they have to bring the promissory note and the mortgage deed. Those two are required. They cannot be separated. They must be together. If they don't have either one of those things, they do not have jurisdiction. They have not granted the court jurisdiction, and that judgment is a void judgment. Okay.
They never do have those things because they separate them right at closing.
They never do. They never do. And then like in Justice's case, it changes about 500 different hands, and it goes from one place to another, and it makes your head spin. That you're trying to figure this thing out. You're like, I'm getting a headache just trying to determine where all of this nonsense has gone.
Right. And in all the documentation of all the people that said, it turns out we finally got a letter from the lawyer stating who the owner of it is some series of numbers, not even a company.
Yeah, it was
and
like,
we're like, well, who's this now?
DM or something, I don't know.
Yes, and it all started with asking for it because of I felt we were being extorted because the company, I'll say it, I'm not shy, Mr. Cooper, when my husband got furloughed during COVID, a complete government shutdown globally, we all know what happened. Due to no fault of our own, have many people were put out of work and lost their businesses, right? They told us the only option they had was we would get a forbearance, which typically means, but not always, you extend the life of the loan. So if you don't pay for 6 months, the loan is 6 months longer. Well, what they said was, well, you don't have to pay for 6 months to a year, however long it was. But when that is over, you then have to pay the full sum of $30,000 or whatever it is. And you're like, so an $1,800 payment right now would be stressful. We're asking for relief, but in 6 months, we're just going to magically get $30,000. So the way I look at that is that's extortion because they offered no other option.
Yeah,
we were under duress and our back was against the wall. What are you supposed to do without an income?
Not only that, I mean, those terms constitute in contract law, those terms constitute an impossibility, number one.
Right.
And it's unconscionable to number two. I mean, if a party is seeking relief right now because they're under financial stress, what makes you think they're going to have $30-something thousand 6 months from now?
Right.
If they don't have it today, they're more than likely not going to have it 6 months from now.
Right.
And they should have known that. They knew exactly what they were doing.
Mm-hmm.
They were doing that because like, hey, we have to do this so that we can go back to our insurance people and say, hey, we haven't collected a payment for 6 months. We need to get that insurance payment now.
And here's the proof they knew what they were doing, because when I wrote to, I think his name is Jay Bray, the CEO or CFO or whatever, the person in charge of the company, and asked him for validation of my original article of indebtedness,
mm-hmm.
I heard nothing. And then all of a sudden, this company called Shell Point starts asking me for $30,000. Yep. And we're like, wow. What happened here?
Mr. Cooper is the doing business as it's Nation Star Mortgage Services.
And they jumped out of the line of fire ASAP.
Yeah, well, they absolutely certainly tried. So, but going back to what we're talking about here. So if you're going to, Erica, let's talk about your friend. Okay.
Yes.
So she obviously is in a situation. It's a she, right? Okay. Sorry. I just presumed. So she has a couple of options. The first option is she can file a motion to vacate the judgment for a void judgment. And she can say, nowhere on the record has it been proven by the moving party, the mortgage company, that they A, have standing to foreclose, B, that anyone with personal knowledge knows anything about this because there's no sworn testimony from somebody from the company saying that, yes, we are an aggrieved party. We have Article 3 standing. We have suffered an injury in fact, right? So she can file a motion into that case. But the issue I run into with that is you're filing a motion and it's going right back to that same judge who just said that they had jurisdiction. What's the likelihood that he's going to, oh, you know what? You're right. I made a mistake. Okay, this judgment is vacated. What's the likelihood that's going to happen?
Not likely.
It's not.
She's part of the crime in the first place. So
yeah. I mean, and a lot of these judges in these courts, is your friend there in Indiana with you as well, or in a different state?
Yeah,
Indiana. So Indiana is a judicial foreclosure state. It sounds like, right? Because she's in a court.
Right.
Okay, so at least you have that. We don't have that luxury here in Utah. We actually have to instigate our own lawsuit, which is fine. You know, it's not a big deal now, but they were counting on this that the majority of the homeowners that were in a situation like this wouldn't know what to do, and they would just let them foreclose, and they think, well, I just lost my property.
Mm-hmm.
Okay, it's very, very clear. Read your state constitution. If you don't know your rights, you have no rights, and you have a right to due process of law. You cannot be deprived of anything, not your life, not your liberty, and certainly not any of your property without proper due process of law. They can't just come in and say, oh, well, we did everything here and this follows due. No, it does not. I have a right to face my accuser. I have to face no one. I have a right to cross-examine someone who's making a claim against me. I had no opportunity to do any of that. So this is how we assert that.
So James, she should file a judicial complaint, should she not?
That's the first thing I would do.
Mm-hmm.
Number one, file a judicial complaint against that moron judge and say, hey, you got a judge in here who doesn't even know the law. So
right.
That's the first thing I would
and for
do.
those who are new to this, can you just explain what that judicial complaint will signal to the judge?
It's not really going to, I mean, all it's going to do is that this is incorporating the politics side of it that Randy talks about, right?
But they do it. So we have some
merit
in doing it, right?
It does. Because again, judicial complaints don't get filed very often. And so if you go file a judicial conduct complaint against this judge and say, hey, this judge not only A, is biased, but B, doesn't know the freaking law from their head. So they clearly don't understand what due process of law is. They clearly don't understand what's required in order for someone to have standing to foreclose. So this judge needs to, at the minimum, needs to go back to law school, but they probably shouldn't be a judge. So that's kind of
gloves are off with this one.
Yeah. Yeah. That's what I would do there. The gloves are off. So in your friend's case, that's the first thing I would do is I would file a judicial conduct complaint. The second thing I would do now, if you want to file a motion to vacate, to put it in the record to show, you can do that. If you decide you want to take it to the appellate court, you can do that. I, for one, would rather attack it collaterally, because then you can sue the people who brought this claim against you for all this emotional distress and time you had to spend here, and you can sue them collaterally. That's the other option. So let's talk about that. What does that mean, suing them collaterally? Let me share my screen again. While I'm opening that up here, what do you guys think a collateral attack is?
After money.
Okay.
I mean, collateral is some sort of belonging in the word collateral, so it's got to be.
Yeah.
I don't know.
So in this term, a collateral attack means you're filing your own lawsuit in another court, attacking the judgment of that court.
So what does the word collateral mean?
It means it's a side by side. Yeah. Okay. It's a side to, as opposed to being a part of the original action.
Okay.
Right. So going back to Erica's friend. So like I said, she could file a motion, which would be part of that original action that was instigated by the mortgage company. But I would rather file my own suit, naming those mortgage people as defendants. You can name the judge as a defendant too, if you want to. It's going to be difficult, but it's the minute that judge issued any kind of ruling or did anything without proper jurisdiction, the judge has no judicial immunity.
Right. So
judicial immunity does not apply when a judge is just acting willy-nilly just because he puts on a black robe and calls himself a judge. Mm-hmm. Right? So where I go to know, okay, when is it appropriate to attack this judgment collaterally? Well, where else but American jurisprudence? So where I'm at right here is I'm under the topic of judgments, relief from judgments, and its collateral attack. And this is the general capabilities of attacking a judgment collaterally. So let's read this. It says, a final judgment by a court of competent jurisdiction is generally not subject to collateral attack unless it was procured by fraud, regardless of whether it was rightly or wrongly decided. Okay? Again, keywords there is competent jurisdiction. In other words, where the court has jurisdiction of the parties and the subject matter, its judgment is generally not subject to collateral attack. So, if the moving party did their job and they A, brought a verified complaint, and B, somebody who could swear to the truthfulness of it, the court has the subject matter jurisdiction it needs. However, a collateral attack may be allowed if the judgment is void, such as where a judgment was rendered by a court without jurisdiction.
Booyah.
There it is.
Would this also be known as a countersuit?
Yes.
Okay.
Well, sort of. Okay. A countersuit is one where, let's say, for example, I was to sue you, Justice, and then you're like, well, you're way off into the weeds. I'm going to go ahead and countersue you. That's a countersuit. Okay. Right? So I've sued you, you're suing me back, and it's all part of one action. This is a whole separate action. Okay. It says here, if a judgment is voidable, a collateral attack thereon is generally unavailable. Thus, even if the judgment was so irregular or defective that it would be set aside or annulled on a proper direct application for that purpose, as a general rule, it is not subject to collateral impeachment as long as it stands unreversed. That's weird. Is that your microphone again?
It's my
Oh, dear.
laptop, sorry.
Okay. Does that make sense, what I'm just saying there? What we just read?
Yeah.
So the key to all of this, you guys, is the fact right here where it says, if the judgment is void, such as where a judgment was rendered by a court without jurisdiction. Now, Erica, let me go back to you. Can you waive in personam jurisdiction? So if you're not properly served and you answer a complaint, can you go back and say, well, I was never properly served. You got to properly serve me.
Yes.
Are you sure?
No.
I love that. Typically, no.
You'd think so,
Because
but
yes, in personam jurisdiction, that can be waived. You can waive that. You can say, you know what, forget about it. I'll go ahead and just move forward with this. All right. Now, on the flip side of things, Erica, can subject matter jurisdiction be waived?
No.
It can never be waived. Never be waived, right? So we went over this last week and the week before. The court must have subject matter, must have jurisdiction over the subject matter, meaning it's a statute or a law that they can hear, happen within their territory and their jurisdiction. As far as that goes, the territorial jurisdiction. It also must be brought by someone who has standing, someone who has suffered an injury in fact. Okay. So let me ask you this. If you are driving down the freeway and you get pulled over by a state trooper and he says, my goodness, what's your hurry there, speed demon? And your answer to him is, I don't answer questions. Good girl. Then he's going to be like, all right, well, here's your ticket. He hands you a ticket. And on the ticket, it says you need to show up in court in this time. Does that court have subject matter jurisdiction to hear that case?
No.
Why?
Because there was no damage to anyone who could bring forth a complaint against me.
There you go. But the plaintiff is the state of Indiana. The state of Indiana versus Erica. And the pompous attorney on the other side is going to say, well, the statute says we have attorney, the legislature says we have jurisdiction to prosecute these things. And this is the proper venue for this. This is a proper court for this. What damage did I cause to any single person? How can I stand before my accuser?
still no harm done.
Okay.
Yeah.
You're moving in the right direction. The question I would ask you is like, okay, who has standing to bring this claim against me?
Right.
Who can prove an injury in fact?
So something closer would be if the actual police officer had her in court between he and her.
But he would have to prove that she harmed him directly.
Right.
Not in his capacity as a police officer, one who is employed by the executive branch. They do not have Article 3 standing.
Right. I'm just saying that would be a closer scenario for the situation, not the corporation, which could be 100 people.
Yes. Yeah. You just, what we're trying to convey here is it is impossible for you to harm the entire state or the corporation of the state. They have suffered no injury in fact, and they can prove no injury in fact. Therefore, they do not have Article 3 standing to bring a claim against you, one of the people. Now, they're going to say, well, the legislature says we can do this, and this is what we're going to do. Okay, that's great. You go ahead and do what you're going to do, but I'm telling you right now, this court has no subject matter jurisdiction to hear this. Oh, and by the way, Mr. Judge, if you choose to move forward with this case, knowing you don't have subject matter jurisdiction, I will personally hold you responsible. There's nothing wrong with that.
Mm-mm.
These people are our public servants. They work for us. You need to tell them that. You work for me, not the other way around.
And when they bring up the fines associated with your crime, then you call out the bills of attainder, right? That's what we talked about last
Hold
week.
up. I'm waving my little flag here. This is my unconstitutional flag. Hey, Judge, you know what? Article 1, Section 24, which I believe is here in Utah, says there shall be no bills of attainder or ex post facto laws. So how is it that the legislature can prescribe punishment? Doesn't that violate the separation of powers? Well, yeah, but the statute is what it is, and they're prescribing these outlines for us, so we have a guideline to go on. Oh, okay. So you mean you don't actually just you don't actually take the testimony of someone who was actually injured and determine the amount of damages based off of that? Is that what you're telling me, Mr. Judge? Ian, what we're talking about are the administrative courts. This is exactly what it is. Okay? It is, I'm here to tell you, it is very rare, unfortunately, that a constitutional court is taking place anywhere. The only time that those courts are invoked is when people like us properly serve someone and properly sue someone. But if you're receiving a summons in the mail or something like that, or you get a ticket from one of these glorified security officers with a badge and gun, that's all administrative, 100%.
And there was something that we saw recently too, Justice, about the seals for the courts to prove that you're an actual court that can even bring this stuff.
Like, yeah, we were talking about that. I don't know. Were you with us that day, Erica? I don't know. Maybe I don't think you were.
It was the last broadcast. She was.
It was sick. The last broadcast. Mm-hmm. Oh yeah, you were sick. Not the last one. The one before.
Oh yeah,
so
yeah.
I had said you need to check the laws there in Indiana because James can't find. I haven't looked, but James said he couldn't find anything to where that is applicable to such a fine-tuned degree here in Utah.
Mm-hmm. Yeah. Yeah, so
and that was a California laws and rules, so you would have to look there.
Yeah, that video was produced by, and kudos to her. She did a lot of work.
Mm-hmm. Right.
But she found the laws and statutes of California that prescribe exactly what the statute or the seal is supposed to look like, what it's supposed to say, how big it's supposed to be. It's supposed to be embossed, all of these things, right? And I couldn't find anything like that here in Utah. The only law I did find was it says that the only time that a seal is required is when it's signed by an officer of the court. Well, summonses are supposed to be signed by an officer of the court.
Right.
So where's the seal? So just because it says summons on there, if there's no seal of the court, it is not a proper summons. Okay?
My peon brain just doesn't understand how these administrative courts are even allowed to be in existence as they are anyway.
Well, so there was a purpose for them, right? When the founders, when they started, putting pen to paper and saying, okay, how do we organize this new nation? How do we create this government, which is by and for the people that are supposed to work for us and protect and guard our liberties? They said, well, we're going to have situations that involve where we're going to need to be able to prosecute people administratively, where they didn't commit, say, a common law crime, but maybe they violated policy. Maybe they violated procedure, which is what statutes are. It's just policy and procedure for all of our government agencies. So that's what administrative courts are for. However,
the agencies who violate their statutes.
But what I'm saying, no, that's what I'm saying is they are misapplying. It's no different than McDonald's trying to charge you for violating one of their policies and procedures. You're just like, get the crap out of here. I don't work for you. Right. I have no contract with you. I have no obligation to you. So that's the same approach we have to take in these administrative courts if we're being dragged into there for one of these quote unquote violations of policy and procedure. We need to just take a step back and say, okay, hold the horses here, Judge. For number one, Randy talks about it this way. Randy Kelton and Brett Fountain, they say, I'm here at arm's length, right? I'm here at arm's length to the court. That's the same thing as I'm here by special appearance. I am not here by general appearance. I'm making that very clear. There is nothing on the record to show that this court has A, in personam jurisdiction, and B, subject matter jurisdiction over me and over this alleged controversy. I'm letting you know now, I have no contract or obligation with the state or with the city or with the county or whoever it is that's moving against you. Whatever name is listed there, if it's the local city, township, village, or whatever wherever you are, they call them. I mean, they're everything in every state. It's different, right? So if it's the village of this, if it's the city of this, if it's the town of this, if it's the township of this, I'm going to require proof that I have a contract with them, because that contract would prove that you can move administratively under me.
Right. Like when they tell me I can't have chickens because of the city ordinance.
Exactly.
Show me the contract.
Hey, Mr. Ordinance Officer, take that ordinance and shove it up where the sun don't shine. That's what I would say to him.
That's what I did
say. If he says, well, I'm going to issue you a fine, be my guest, but don't you ever step foot on my property again without a proper warrant of the law. Otherwise, I will use the force that I have at my fingertips. Right?
Right.
So you're right. Who is to tell you can't have chickens? Are those chickens harming you, or are they infringing on anyone else's rights?
Right, and they're not precogs from the Minority Report that can anticipate that it's going to be a problem someday, maybe for someone.
Exactly. We had this discussion, and I want to get back to Ian's question here in a minute, but we had this discussion the other day when I was driving with my family. I was driving down my road, and it's not a country road, but it's not a very busy. I mean, there's very rarely any traffic on this road. But, these people have put up those ridiculous speed limits that have, it tells you what your speed is, right?
Yeah.
Have you seen those? Those digital
Yeah.
Radar guns, and so the speed limit's 35 and I'm going 42. And my kids are like, Dad, you're speeding. That's against the law. And I'm just looking around going, okay, and who is hurt by my actions?
Mm-hmm.
Right.
Whose rights did I infringe? If there was another car on the road, I would slow down.
Right.
Right. That's because we're competent adults and we can grow up.
Well, you know what?
Use the brain that God gave us and know that, hey, it's common sense that I shouldn't be driving this fast if there's other people or cars around.
Some adults are not competent. We have one of those in our neighborhood. Now imagine this: a neighborhood,
Mm-hmm.
children and animals,
Mm-hmm.
wildlife. 3 moose have been killed in my neighborhood because people speed down the road 50 miles. That we have a straight shot. And it's very sad. A mother and a baby and another baby because of people speeding. So some adults are not competent and
they're not
always in a hurry. And they had speed bumps. They took them out. We have one of those in our neighborhood for that very reason. They literally, the neighborhood paid to put a moose sign. If you go above 25, all the lights start flashing to remind people. And it's not just that. I mean, you can get killed yourself too.
Yeah, I mean, there's a reason why those speed limits are there. Use reasonable prudence, people.
They're suggestions.
Yeah, it's. I go back to the whole Pirates of the Caribbean thing, right? Where that lady says parlay, and she's like, "What?
Mm-hmm.
Parlay? I invoke parlay." And he's like, "By the rule of the Pirates Code," he's like, "Whoa! Those are more like guidelines."
Mm-hmm.
That's kind of what I think of them as. But the point I'm trying to make here, guys, is we have these laws on the books for a reason. But it's just like you said. It's like, well, we don't have precogs that are going to tell us when the next crime will happen so that we can go stop it before it happens.
Right.
It's not the unfortunate thing about this world we live in with the people that are on this planet is we are always going to have somebody who's going to do something stupid and hurt someone else. There's just no way around that. That's why we have this resolution process. So Ian had a great question. So you're stuck in an administrative court. How do you flip this into a judicial process? That's a great question, Ian.
It is a great question.
So from my experience, there's really nothing you're going to be able to do in that administrative court to turn it into a judicial one. They're just going to ignore everything you do. Well, we don't do stuff like that here. Don't come in here talking to me about your constitutional rights. You don't have those here. I've actually had judges say that. I've heard judges say that. And
can you invoke a common law court?
No, there's just really nothing you can do. So here's my suggestion, guys. If whatever you're dealing with, if it does not deal with jail time, okay, if jail is not on the table as where they want to send you to jail because of this, I would file paperwork into that process. I would object to everything they're doing, put it on the record. The court has no subject matter jurisdiction. The court has no in personam jurisdiction. There's no one with no one who has suffered an injury in fact bringing a legitimate claim against me. I would file that paperwork as a motion to dismiss into that court. Let that judge go ahead and ignore it. Great. You sit right there, Mr. Judge. I'm going to go sue you over in federal court. That's my collateral attack there. I'm going to go get an injunction from the federal court saying this court is attempting to prosecute me administratively without affording me my due process rights, without proving all of these things. I am likely to succeed on the merits of this case, and no one is harmed if this court grants this injunction. I'm going to file a lawsuit alleging deprivations of my rights under the color of law, Title 42, 1983, and I'm going to file a motion for a preliminary injunction along with that. Get that federal judge to sign that paper that says, hey, moron, stop doing what you're doing. That'll put a stop to it.
So, James, is that a collateral attack?
That's a type of a collateral attack, yes. It's not the collateral attack in what we're talking about here. Now, let me go back to the next thing that I was saying. What if jail time is on the table? What if they're trying to put you in jail? Unfortunately, they're your only option, and I haven't found one away. I mean, you can try to go the federal route. Sometimes they move pretty quickly. Sometimes the only thing you can do is accept some type of a plea deal. Now, let me remind you, just because you accepted a plea deal does not mean the court had subject matter jurisdiction, because you can never waive that. So just because you accept a plea deal, and let's say the prosecutor says, all right, well, I will take jail off the table, but you've got to be 6 months this, or you got to be confined to your home or whatever. Just anything that can give you your liberty back until you have the time to fight it properly. So even if you accept a plea deal, you can still attack that judgment because the court never had subject matter jurisdiction. Never had it. So does that answer your question, Ian? I hope so. I hope that answered what I don't know. You guys tell me. Does that answer the question that he was trying to get?
Yes, it seems like it. It seems to me. How do you get it out of the administrative courts into the judicial court?
Yeah.
By counteraction.
Yeah. Well, there are a couple of other things we can do. So let's talk about, all right, how do we initiate this collateral attack? Let's say it's one of these minor misdemeanors, or it's a traffic offense, or it's something just minimal. And you're just like, I'm tired of this. I'm tired of these people running me through the ring, extorting my money, my hard-earned money from me. So what can you do? Well, you can file what's called a petition to vacate a void judgment. And I'm going to pull one up here for you guys.
Petition to vacate a void judgment.
Yep.
Okay.
So many of you guys know I am a big fan of Richard Cornforth. Mm-hmm. He's the one who said he discovered this back in 1993, I think he said, 93 or 94. So it's been a long time ago. He talks about these people here, this Melvin, this Bessie, these other people. Just a quick backstory. These folks here were all homeowners in a homeowners association in Arizona. And I don't know exactly the whole details, but somehow there was commingling of funds. So these people chose not to pay their homeowner association dues. Because of that, there was somebody was extorting, but what's that word I'm looking for? Embezzling. There we go. They were embezzling money. And so the Happy Trails Acquisition Limited Partnership decided to sue them. So these guys, these people here, this Melvin and the Bessie and these other folks, they decided to play the Patriot mythology games. You guys know how well that works out, right? It's very similar to the Hunger Games. May the odds be ever in your favor.
Yeah, I'm still searching for someone that's had success with that.
Well, I'm here to tell you these folks didn't have success. They filed sometime. I mean, Richard in the video that I watched, he had a copy of their pleading, and it was the size of a 3-ring binder that was 3 or 4 inches tall. That's how thick the pleadings was. So they went in there and they just said, we stand on our pleadings. They didn't say anything. We stand on our pleadings. And apparently the judge in this case tried to do everything he could to help them, but they just wouldn't listen. So they ultimately ended up losing, and they got a $6.8 million judgment against them. $6.8 million.
That's heavy.
Okay. So what's interesting is the judge in his order said that they were all severally and equally liable for that judgment. So what that means is everyone had to pay an equal amount that would equal that total of the $6.8 million.
Oh, and how many of them are there? 6?
There was 1, 2, 3, 4, 5, 6, 7, 8.
Oy.
Okay, still, for 8 people, that's near impossible. So they reached out to Richard, and he looked into this, and he's like, all right, well, let me take a look and see what I can find. And he found in Arizona that they passed a statute, right? Statutes are policies and procedures for members of the public organization, people who work for the public. And the statute prohibits that a court can issue a judgment that is equally and severally liable. They can only be liable for their portion. They cannot be equally and severally liable.
Mm-hmm.
That make sense?
Yeah.
So he wrote up this petition to vacate a void judgment. And so for those of you who might be listening, it's only 4 pages long. 4 pages to vacate a $6.8 million judgment. And this is what it says. It says, these individuals, I'll save some time and not read their names, hereinafter identified as plaintiffs, petition this court under the authority of Arizona Rules of Civil Procedure and the common law doctrines established in American Credit Bureau versus Pima County for vacation of a void judgment in case number, a copy of which is attached. The face of the record shows that the plaintiffs in the above styled cause were not in receipt of notice of complainant's motion for summary judgment in the case, had no means to know of motion for summary judgment or the hearing conducted to determine liability. The plaintiffs were deprived of procedural due process rights. The clear face of the record shows that the court did not have jurisdiction over the parties, a procedural due process requisite for determining liability. Jurisdictions of the parties and subject matter is essential to a valid judgment, and court must have jurisdiction to enter the particular judgment. A judgment is void on its face and is subject to collateral attack unless court has jurisdiction of the subject matter of the persons involved in the litigation and to render the particular judgment given. He says this trial court had no jurisdiction over person of defendant who was never served with a summons and complaint, who never appeared in the declaratory judgment action, and who only filed notice requesting copies of all minutes, entries, and documents long after trial. Therefore, judgment as to such defendant was void. So then there's some cases here that he's using to back up his position, which is what we should do. He says the complainant's action to determine liability was not procedurally or substantively a provisional remedy. Before any provisional remedy shall issue, the party seeking such remedy shall establish with particularity by affidavit to the court's satisfaction sufficient facts supporting the party's claim and establish that one of the requirements of subsection A of statute authorizing provisional remedies has been met, and that such party will file such other pleadings or affidavits as required by law as a prerequisite to the issuance of any provisional remedy sought. Okay. He talks about how the court wanted subject matter jurisdiction to find all of these folks jointly and severally liable. Mm-hmm. It says the court made no inquiry into individual culpability of each respondent. The court failed to apportion degrees of fault. The court in this case made no finding that any party was responsible for the fault of any other party. And this is where he talks about joint and several liability has been abolished in Arizona, excepting where degrees of fault have been apportioned. Okay, I won't go through everything else here, but basically that's how you attack a void judgment collaterally. You file a petition, which is nothing more than it's another case in another court, and you attach the record from that other court. So going back to your question, Ian, where you're saying, what do we do in these administrative courts? Well, you're still going to get a copy of that record, and you're going to say, I need a certified copy of the court record. They're going to give you everything they have. They're going to show all of the paperwork you filed into the court. You're going to attach that to your new lawsuit, and you're going to go sue them in another court. You can sue them in federal district court. You can sue them in another state court if you want. It doesn't matter where you want to go. I just prefer the Fed. That's just me, but you can go wherever you want. And that's the process for how you do that.
So now, James, is this like another way of filing a motion to dismiss?
Sort of, right? Because
you're just trying to get it.
You're trying to get the judgment vacated because, again, the court can, going back to what we talked about before, right? Courts inherently do not have jurisdiction to hear matters. They cannot on their own just go ahead and, we're just going to go ahead and prosecute this person.
Right.
They can't do that on their own.
So when it's vacated, is the case over with? And when it's dismissed, is the case over with? Or is there additional steps on each?
No.
Okay.
No.
So they're both, the result is the same.
Yeah. So if you file a motion to dismiss in the administrative court, and you actually have a judge that has a brain in his head, is like, I don't want to mess with this guy.
Right.
And he dismisses the case.
Right.
The case is over.
You see that this case is dismissed and it's done.
Yeah.
So I was curious if that meant you had to, with the voiding, if you had to continue on with another type of action afterwards.
No, it doesn't happen. It doesn't happen very often, but it does. It does happen. So, but if you file a petition in another court to vacate that court's judgment, you're entitled to damages. Because guess what you have? What do you have, Erica?
Subject matter jurisdiction.
Yep, you have standing.
You have standing, yeah.
You can prove actual damages. This court subjected me to an unlawful fine. Let's say it's $1,000. They fined me $1,000. This court subjected me, so I have actual damages of $1,000. And I'm suing them for punitive damages to make sure they don't do this again. That's what punitive is. We talked about that last week when we're talking about, what constitutes a bill of attainder. It's legislation that prescribes a punishment. And if that's typically a punitive damage, like we said before, if the statute says, whoever's convicted of this must pay $1 million fine, it's like, well, who gets that money? It's not you. It's not whoever was damaged. It's not whoever was hurt. That's a punitive damage. So that's how that works. That's what I would do, right? I'd also bring up the same thing in, if I'm collaterally attacking this in federal court, I would bring in and say, hey, this process violated all sorts of rights. Not only that, it violated the constitutional provision that no bill of attainder should be passed. Because as this moving party was applying this law to me, they were misapplying it to me. There's no contract. There's no obligation that was entered onto the record by validation by anyone who has personal knowledge of it that would prove that this statute applies to me. So, yes, Ian, you would just pay the fine at the admin level. I mean, if it's not a serious fine, a lot of these stupid administrative courts will do a payment plan for you. Sure, whatever. Do whatever you got to do to get out of there and then go and attack it properly. Because the only way that madness stops is when more and more of us start filing these collateral attacks.
Right.
Start suing these people.
And more and more people are aware.
Yep.
So when you were showing, I know there's numerous websites. I think it was Brett talking about some today where people can go to learn these definitions. And because these things are very confusing, right? How would somebody know unless they're watching something like this? Or where do they go to learn the definition? So you had just had a website up, and I know there's another one called Pacer that he was talking about. Explain some of these websites for the folks that they know where to go get some resources. So besides some we're going to share at the end. So the website I had up was American Jurisprudence. And that is, unfortunately, you can't just get it for free. I wish it was, because it's super valuable information.
So it's actually available through Westlaw Classic through Thomson Reuters. There is a subscription cost to it. It's not terrible, but it's not cheap either. So again, they're mainly, this is mainly made for the attorney profession.
So this is westlaw.com.
Yeah, it's westlaw.com. Yep, you can search it out. Search for American Jurisprudence. You'll find it. You'll find a way to subscribe to it if you want to. You don't have to. Again, if you go into our group in Telegram and say, hey, can you find what American Jurisprudence says about this? Then I will
Another really good resource too is like here in Indianapolis, we have a law library, and the people who work there know everything. And and they have subscriptions to everything. So if you just go in there and you tell them what you're looking for, they can help you find it.
Yep. This is a great, good question, Jolanta. So I'll let Justice tell you what she did, but basically she just wrote to him and said, I need proof. I need proof of who you are.
So in other words, did they extort you after COVID as well and ask you to pay everything up front? So, whatever your situation is, if you're wanting proof, James told me to ask them for the original articles of indebtedness. So that since that's who I was dealing with, my original mortgage started out with Citibank. And I can't even tell you the long debacle up to this point. But they seem to have sold or transferred the loan numerous times up to this point. And when I wrote directly to, I believe it's James Bray, you can look up the CFO of any company or the CEO of any company online. You can look for their headquarters, their address, their corporate, address and so forth. And I sent a return receipt registered letter asking him for the original article of indebtedness. It's the only thing I asked for. And I expanded that list as we went on with other people. But from that point on, I heard nothing from anybody from Mr. Cooper. And the next thing was I started getting statements from a company called ShellPoint. And they were trying to then collect, I think it was $30,000 at the time.
Yep, they still are.
And now it's up to 50 or something. And nothing's happening. They just keep robotic, keep sending statements and so forth. And I keep asking ShellPoint, who are you? Where did you come from? And why do you think you're entitled to me paying you any money? Yeah. So have no idea why and when, but clearly Mr. Cooper must have, is my assumption. You know what they say about assuming, put them to try to collect the debt. It's a collection company when you look them up. And when I started asking for them, same thing. Not only did I ask them for the original articles of indebtedness, which they would need to provide a certified copy of it. Or I even said, you send it to me, I'll send it back, right? But they didn't offer anything except for a photocopy. And I said, in this day and age of digital fraud, number one, how do I know something's been tampered with? There's fraud running everywhere. And my whole purpose for this letter is to see if mortgage fraud has been committed. I was upfront with them. Yeah. Because I believe it has been committed. And I believe long before these people even got involved.
Yeah. It goes back pretty far back.
Right.
But real quick too, Justice, not to cut you off. If you request validation from these people, right? So there's a federal law. It's the Fair Debt Collectors Practices Act. Most of these, unfortunately, mortgage servicers do not fall into that category, which is ridiculous to me. But the Congress has said when you request validation, that requires somebody signing something under penalty of perjury that what they have is real. So that would suffice too. So this document that they send back to Justice, where it was just a photocopy, if they had done their job and went out and said, I swear under penalty of perjury that we have this document and we are the owners of this and it's notarized, that changes everything. But they didn't even bother doing any of that.
Right. So the document we're looking for is the original contract with our wet ink signature.
That's the promise.
Not a photocopy. Yeah. So that's what we were asking for. And no one has been able to provide it. And they're saying that this is valid. So my thought is, if a photocopy of my original contract is valid, then so is a photocopy of my driver's license. And I can hand that over to the cop.
Yeah.
And I can hand that to the judge when I go in to prove who I am. It's not valid. It's certainly not valid at all in any way, shape, or form, and wouldn't hold up in a court if I were to go into court and show them a photocopy of my driver's license or a photocopy of my marriage license or birth certificate at the motor vehicle to attain my license. None of that is valid. So it's escalated because they sent a copy, and I said, I also want to see where, I don't know if you guys know this, but it's illegal to lend credit, right? So they have had to fund the bank account. And I said, show me the funding of the bank account.
Show me the accounting.
Right.
Yeah.
And so anyway, to make a long story short, they're not providing any of these documents whatsoever. And just so that you know, as James said earlier, I don't know when you came into the broadcast, but Nation Star is the originating company, and they changed their name. I still believe it's part of the same corporation, isn't it, James?
Yeah, so Mr. Cooper is just doing business as.
Right, okay.
So they are Nation Star Mortgage Servicers doing business as Mr. Cooper.
And there are class action lawsuits, a lot of them with Nation Star, which is probably why they changed their name. But so that's what you're asking for, you're asking for, a certified copy of the original article. You want to see that someone has, because the contract is null and void if someone doesn't have it.
Yeah.
If they don't have your original wet ink signature, mortgage, and note together, the mortgage is null and void.
Not only that, Justice, but here's the other thing too. The contract must be one that can be assignable. You have to agree to that. They have to agree to that. How many of you, Erica, when you bought your house, did you sit down and read through all 365 pages of closing documents?
No, they just hand these papers to you and they give you the gist of it. They say, this is just saying that you blah, blah, sign this.
This is saying this. This is just saying this. So do you really have a meeting of the minds?
Absolutely not. They don't tell you that you're funding your own loan. Like that's essentially what's happening. They don't tell you that they open up an account for you on your behalf to obtain the funds, which they then use and make tons of money off of it.
Your promise to pay.
They dig into the coffers from the Federal Reserve, right?
And they separate, and you can subpoena that after you file your case in the discovery. It's called the OC-10 with the Federal Reserve. It's this whole packet of information that they file for you to obtain the funds that way. And then they put it into their accounts as a deposit and then pretend like they're loaning it to you after you just created the money. And then tell you to pay it back with interest.
Round and round and round we go. Where we stop.
And the second you do the closing, they separate your mortgage from your promissory note, because then they use that promissory note to make money off of it. You can get a securitization audit to see just how far around the world things go.
That's illegal. That's called bifurcation.
Yep.
And the note has to stay with the mortgage. So when they separate one electronically to have the process done quicker, it's bifurcated, and that also makes it null and void. There's a really great video. We have it in Affidavits 101. I'll dig it up and post it. So if you're not on Telegram, I'll put it also in the notes of the YouTube channel, and watch it. It's 20 minutes, and this gentleman explains it step by step of the mortgage fraud process, which is pretty much almost everybody in America. The last modification did on my loan did say it's not a MERS loan, which MERS is the electronic version. So I think that because they've been caught now, they might have stopped doing that. I have no idea, but there's this guy explains it beautifully. So to give you an idea of what's going on with the fraud of this, I'll put that in there so you guys can listen to it. I highly recommend it.
Yeah. You guys can see where we're going with this. I mean, it's just a mess. It's an absolute mess. I mean, Ian, who knows?
That's a great question.
Who knows who holds the original note, right?
This is what we're searching for.
The idea, this is the simplicity of this, how it's supposed to work, right? I go to Justice and say, Justice, I need a loan to buy a house. Justice says, okay, I've got the money. Promise you'll pay me back over X amount of years, and you'll pay me X amount of percentage in interest. So I say, okay, we agree. I sign the papers. She signs the papers. She hands me the money, and away we go. I sign over to her a promissory note, which is my promise to pay the money back. I sign over to her a mortgage deed, which grants her ownership and interest in the property Should I fail to pay it back, she can foreclose. That's how simple this is. Both documents are required. They cannot be separated. And they do it all the time.
Right.
They do
And
it all.
there's a great little book too. What is it called? My home is my castle.
My home is my castle.
Yeah.
And it talks about the process as well. You could get it on Amazon.
Yeah. I mean, I know I apologize. We're kind of getting off on the weeds here, guys.
Yeah.
But God, we could spend another 2 or 3 episodes.
Yeah, I think we want to do one on mortgage fraud specifically. So
yeah, we absolutely need to talk about it in more detail. But for the purposes of today, I wanted to teach you and give you tools on how you can do that. Now, I am going to be working on some of these things, and for everybody that's on Telegram, every single document, every lawsuit, every motion, every petition that I write, I post there. I put it there for you guys to have it. Because I'm a visual learner. I need to see an example of something. It helps keep me in line and go, okay, this is how it should be written out. It gives me a good timeline of events. So I post every single document that I write in any of the cases that I'm working on in my affidavits channel. You guys are welcome to go look them up and use them for your purposes. So with that, going forward for our next broadcast and more broadcasts down the road, I would like you guys, those of you who are watching or listening, to reach out to us. Reach out to us on Telegram. Reach out to us through YouTube in the comments section. Reach out to us on, where are we? We're on Twitter now, apparently.
yeah.
Reach out to us. If you have a problem that you're dealing with and you want some step-by-step help as far as this is what you should do, when you should do it. Ian, I see that you can't post on my Telegram page. Post it in as a comment on YouTube. If you want help, I want to start dedicating more time to bringing you guys on, if you're willing, to talk about your situation. We'll talk about what you can do and your next steps going forward. So even though we're not on a radio broadcast, so to speak, where people can call in, I'd like to kind of create that type of an environment. So that's what I'm thinking. What do you guys think about that?
I think that's a great idea. We can do live workshops and Q&As. I mean, we always have the Q&A, but to bring someone else on the video to talk about, that was the wrong one. And we also, don't forget, we created this at the get-go. And it's very simple. Some things need to be updated, but it's the simple steps through this process, which is accompanying your lawsuit, which is a major part of it. We do have a website, which we're going to be updating, but I think that's a great idea, James, for sure.
I know there was a gentleman who reached out on Telegram asking if I would be willing to do a one-on-one. I would love to. I can't. I don't have the time to dedicate to just do one-on-one, but what I can do is bring you on to the podcast, to the broadcast. Let's talk about your case. Maybe there's somebody else like Jolanta who is dealing with the same issue that Justice is. And so if we can talk about what you're dealing with, what's going on and what's happened, maybe we can give you some ideas. Again, this is not legal advice. Don't take anything I'm saying as legal advice. If you do, you need to have your head checked. There you go. That's my disclaimer. Okay. Maybe we can give you some strategies, some tools that you can utilize in your own situations. So, and yes, Jolanta, she brings up a great point here. She's like, bank foreclosures would be a great one. We are starting to see more and more of that again, right? It's 2008 all over again. Starting to happen again. There was a lot of changes that they made after 2008 where they made it near impossible for anyone to get a home mortgage. They're loosened those restrictions again, and now we're starting to see it again as interest rates have been creeping back up, thanks to this wonderful economy we're living in right now, with people have money coming out their ears. Erica made this awesome face. Remember, Erica, there are people listening on podcasts, so you need to express your feelings through your voice.
Oh, okay. I just made a crazy face.
She's like, that's not right. So,
and we're I've reached out to Richard Cornforth also because he specializes in mortgage fraud, just like Steve Emerson specializes in property taxes and so forth. So keep your fingers crossed. We get him on the show to help, and we'll do a show focused on that because it seems to definitely be.
Yeah, it's a big issue. It's a big issue. I mean, we can talk about, down the road, we'll talk about credit cards, right? How many of you have been hounded by a debt collector that has quote unquote bought credit card debt from somebody. Credit cards are revolving contracts. It's a revolving contract and it cannot be sold.
From what I understand, even debt collection companies are illegal.
Yes, to a certain extent. If you know what you're doing, I mean, they're skirting that line, right? Getting right next to the edge. Some of them go a little bit over and they come right back. A little bit over, they come right back again. If you know how to handle debt collectors, you'll never hear from them again. I got a letter in the mail from some no-name company saying that I owed them money, that they bought this debt from Sprint. I had Sprint like 5 years ago. Now out of the blue, I'm getting something from. I was like, "Who the heck are you?"
Yeah.
I wrote a letter back and said, "All right, go ahead and prove this. I'm going to need this, and someone's going to need to sign under the penalty of perjury. This, and this, and this." I got a letter back from him that says, "We checked with the original creditor. This is valid." I was like, "I'm using that to wipe my rear end because that's about how that's how much how much that paper is worth that you just sent that letter to me on." They did nothing that I asked for. So if they continue to harass me, well, I'll take it to the next level. I might be nice and send them a letter that says, "Well, here's your notice and intent to sue unless you leave me the crap alone."
Right.
So
I just got something from Sprint too. They must be
it's when they merge with T-Mobile, all crap. It all hit the fan. It's nuts. So.
They're all the same company anyway. They're all owned by BlackRock, so it's really such an illusion.
You just keep taking us down those tangents that I would love to go, but I can't go there today, Justice. We don't have time.
I know. Sorry. Write it down on your notepad. There's so much.
I got it right here. So, all right, everybody, we're wrapping up to just about shy of an hour and 15 minutes. I always say I want to keep them to an hour. We end up going a little longer. I hope this is good information. I really just want to empower you people. I say you people. I want to empower people to know what to do. I'm an action taker. When I was learning this stuff, I would hear people. I was like, "This is great, but now what? What do I do? How do I affect these change?" And I'm hoping I'm giving you those solutions. If I'm not, please let us know in our Telegram channel, in the comments section of the YouTube video, on Twitter, on all of these platforms we're on. Let us know. Let us know what we can do to make this easier to digest and help you guys get the remedy you need. So
I think we need to bring Erica's lawsuit to the forefront and go through some of that, because between the medical and the military and all these people that have been.
Oh, that reminds me, Erica, did you see? I was reading a complaint that would be perfect for yours.
Oh, I found a really good one too. I'll have to share it with you. I'm on the live.
I found one that somebody posted, and it's ESPN is sued by former workers. Did you see that one?
No, I haven't seen that one.
I'm going to text this one to you because this is really good. Read this one because they do a great job of creating the nexus between the state and the private actors, which is what you have to do.
Right.
So, I mean, it's 83 freaking pages long. I don't suggest that by any means, but it's really good in some areas. So take a look at it.
I'll send you one too. It did a really great job of connecting with the state nexus and brought forth all the fraud and proof of it in addition to it. So.
Okay, cool. Good to know.
Yeah.
All right. With that, everybody, I'm going to tell you happy Friday, Friday the 13th. Oh, geez. I didn't even realize that. Friday the 13th.
It's a good luck day.
We love Friday the 13th.
Me too. Not
Friday the 13th, January 2023. So with that, I will leave you guys in good hands. Have a great weekend. Have a good week, everybody, till we talk again. Thank you all. We love you. Appreciate you. Signing off from the Justice Revolution.
Okay. Bye, everybody. Have a wonderful weekend. Bye, Erica.
Bye.
See you guys.
James.